Ladies and gentlemen, we have reached the last part of this legal session, and now more or less the floor is yours. If you have questions or observations, you are very welcome to make them. Geraldine.
Is that on? So my question is for you, Michael. You indicated that the IMO, rather than focusing on new instruments, is, really focusing on, sort of implementing what they have. But I had thought that I heard there was some new thing being developed that was a result of a lot of these disasters with cruise ships and ferry ships, where you've had a lot of passenger loss. And I'm just reading about the recent one in China where, a few people get off and it's always the captain, and, hundreds of people are killed. So I thought, is there something being done in one of the treaties to address that, or a new instrument?
Thank you. Yes.
It's on? Yeah. Yes, you can hear me? Thank you. Well, I think that's right, that there's a lot of work that still needs to be done, and of course law is an ever-evolving process. I think the point is that the legal framework is very much in place, and that's provided by the UN Convention on the Law of the Sea and the foundational treaties of the IMO. But there's always additional work that's needed in terms of the implementation of those legal frameworks in the form of guidance and procedures, and how those instruments are actually implemented on a day-to-day basis. One of the real challenges in international law, of course, is, and this is so clearly demonstrated in the work that's being done in ports, is how these different areas of the law intersect in places like ports. And the work that's been done by these different organizations in the world is, we talk about this phenomenon of stovepiping. We have the work that's being done by the FAO and the IMO and the ILO. And we're only beginning to get a sense and get better at the way to integrate these different areas of the law. And so these three organizations in particular are working on developing guidance for the practical implementation of some of these instruments on a day-to-day basis in the activities of ports, for example. So I very much take your point that there is still very much to be put in place, the guidance and the day-to-day practical instrumentation, or the advice for, and training in particular, for these instruments to be implemented. But the sense is that in large part the legal framework around that is very much still in place.
But is there anything specific, like even an IMO work group working on passenger safety issues?
Yes, of course. I mean, this is something that's dealt with on an annual basis by the IMO. It works in different committees. So there's the Maritime Protection Committee, there's the Maritime Safety Committee. And each of those committees have sub-bodies as well. The Facilitation Committee, other subcommittees that work on these very specific issues. And so this is very much within the stream of the work that's being done by IMO.
I mean, with regard to passenger safety, of course, the IMO already implemented the SOLAS, the Convention of the Safety on Sea, which contains a lot of stipulations about safety. There's also, with regard to liability and passenger casualties, we have the Athens Convention, which is certainly not improving safety, but rather clarifying the results of such a tragic disaster which just happened in China. And I don't know whether China is a signatory state of the Athens Convention, but that needs to be clarified. And finally, I know that the classification societies, that they harmonize their standards a lot, and they're working hard on improving the classification rules to have a minimum standard of security. Thank you.
Thank you. I saw another question.
I had a question for Mr. Shewchuk as well. And by the way, just one comment on the last question that Geraldine had was with regards to the Marine Safety Committee and issues like that, very often repeated incidents like this with ferries and so forth, and migrants and sinkings of vessels with migrants create resolutions in front of the IMO and the Marine Safety Committee, which then eventually may lead to proposed codification, a code that deals with a specific type of craft, passenger craft, high-speed ferries, and so forth, to deal with that particular issue above and beyond the Safety of Life at Sea Convention and so forth. And my question had to do with the legal framework of UNCLOS with regards to some of the IMO conventions, like the 1958 High Seas Convention, the 1974 SOLAS Convention that we just referred to, and the 1979 SAR Convention. UNCLOS provides a framework that is an umbrella for those conventions as far as their implementation, I believe, based on what you were saying earlier. And in particular, I had a follow-up question that was related to, you mentioned that UNCLOS provides a way for, I guess, enforcement of some of these conventions, even for nations or port states that are not signatories. And so I was wondering again about how those conventions fit within UNCLOS and the enforcement, particularly for non-signatory states.
Thank you for the question. It's a very unique exception to the principle in international law that international treaties only apply to the parties that consent to be bound by them. This is a fundamental principle in international law, and UNCLOS, and this is, you know, there's many different ways of trying to address these problems, but it stems in large part due to the inefficiencies or the ineffectiveness of flag states to actually control some of their vessels. Is that there needs to be other catch points, there needs to be other ways in which the international community and the states can give some effective control over substandard vessels. And so one of the ways that this is achieved in UNCLOS is to allow for coastal states, or to require coastal states to be bound by international rules and standards that are developed by other organizations. And in the case of maritime safety and security, those rules and standards are developed by IMO. And so we know the parties that are signatories or that are consent to be bound to those instruments, but UNCLOS also allows for its own state parties to be bound to a certain degree by those instruments by requiring them to give effect to or to implement those international rules and standards. So it's a very unique exception to the otherwise very clear legal principle that states are only bound by the treaties that they consent to.
Bernhard Zampolin, Port of Hamburg. I have a question to you, Franz, actually, and to Mr. Hasche, or rather, maybe it's even only a remark. I noticed in my former life as a lawyer and translator for contracts, and that often the problem is that if you have two parties coming from different countries, you choose the English language because it's universal automatically to design and draft the contract. Then you have the problem how to introduce the law instruments that you are referring to. So I'm very much a fan of your campaign for using the local law that you're familiar with, but sometimes there is no translation for our law institutes, for our law instruments in the English language. And then you're often tempted into also choosing the jurisdiction because you're already drafting the contract with all the words and institutions that you know from common law. And that there is a real danger lurking in the, I'm sorry for the English-speaking people here, in the English language. Because you use it because you have international parties, you want a common ground with the language, but then you suddenly slip into the jurisdiction and into the law system of the common law, because that is what goes without saying, or goes with the English language. And yeah, I just wanted to sort of give you that for your campaign. I think that's a very important point to come down to. Maybe it's sometimes better to have a bilingual contract rather than an English one, because then it's easier with the jurisdiction clause.
Well, thank you for your observation. But on the other hand, if the two contracting parties are not coming from an English-speaking country, the English language is a neutrality-seeking instrument in its way. But you're right, the language as such is very important, and we are too easy to think, if you are coming from a non-English-speaking country, that you are able to understand it, because there are great differences between having learned English and the practice of English in law. So that's a good observation. On the other hand, if I might add something to the observation, I may give the word to Dr. Christoph Hasche. We elaborated very technically on the differences between all jurisdictions, but maybe you can add a few words about, maybe Bernard already touched this, language, but culture.
Yes, thank you very much. You're totally right that cultural differences, and this also includes language differences, might cause problems. I would be reluctant to recommend or to draft a bilingual contract. It's fine to work with a translation, but you should really know which version is the decisive one. So in case there is a difference in the two versions and two languages, then you really know to, have to know which contract is the one which really is binding. When I draft a contract in English language, but which is governed, for instance, by German law, then I always put into the contract or into the wording some German phrases to exactly explain. There are legal terms which have a very clear definition under German law, and if you just translate them, someone might not understand that I meant exactly this particular term. So that is a way how to kind of circumvene this problem or solve this problem. With regard to culture clash, that of course is an issue in any international contract or cooperation. Due to globalization, we are more and more used to understand the different cultures, and there are hundreds of thousands of good example where disputes are properly solved between parties from different parts of the world. But I also agree to what was said. It's always easier to evaluate a legal position if you are familiar with the legal system, not only the procedural issues, but also, or more importantly, the substantial law questions. If on the other hand, you said that very often, and you correctly said that very often, if you have a contract, let's say, from between a Chinese company and a German company, both sides do not like to agree on the law of the other side. So then you need sometimes a neutral third country or third jurisdiction, which implies the necessity to step out of your own home turf and to agree on something which is not that close to yourself as your home jurisdiction, which is normally not a big problem. Because in these cases you will always find an expert in that country which is then chosen, which would help to link the gap between the two cultures. Is that an answer?
Yeah.
Thank you.
Thank you. Marcus.
Can I just add something? France.
Yes, of course. Go ahead.
Even within our good old adversarial system, there's advocacy within that. So, if, for example, in Australia, Australia has exports 300 million tons of coal a year, similar amount of iron ore. That's a lot of ship movements. That's a lot of charter parties. Almost all of those charter parties have got London law and arbitration in them. Australian lawyers push hard to get Australian jurisdiction clauses put in there for their own business reasons, if nothing else. They've had an uphill battle over the years. I've been involved for 20 years in this, and I've never really seen it take off. And I think that one of the reasoning there is that the independent point of view, where you've got an Australian business and a Greek ship owner, for example, London's independent of those two. But also I think a factor is that London has the experience, and people are reluctant to buy in to the unknown, and they know what London's about. They know there are experienced arbitrators in there. It's a bit chicken and egg, because until you get a go, you can't get the experience. But for the moment, it strikes me as status quo, actually, is what's happening there.
Well, thank you. But, well, maybe there is a culture factor in that too. People are acquainted with London. It's a big shopping town. Like to go there. So, yeah. So I can't imagine why in Australia you don't find your common ground to work on arbitration there. And the same goes for other regions here in Europe. Dr. Harsje called Hamburg, which is very well equipped, but also other regions in Europe. If I may make a little bit of promotion for Rotterdam, that we have arbitration possibilities there as well. So I think it is possible to find other approaches. I think we have time to take a last question in. And if, yeah, Mr. Inouye.
I have a question to Mr. Suchuk. I'm interested to know how the law of the sea react or deal with the climate change issues. Particularly sea level rising will definitely affect the definition of benchmark as you illustrated in your slide. So when it comes to a definition of the territorial sea, I suppose each country is responsible for updating or a new definition of their shorelines, right? If that's the case, not every country is able to do this in a uniform manner or at the same time, just because of the lack of expertise or lack of funds or so many things. I wonder if UN is providing some type of assistance to these countries as a basis for implementation of the law of the sea. Thank you.
Thank you for the question. It's a very good one, and it's something I think we struggle with, and the international community is struggling with as well, is what is the nature of the ongoing obligation on the part of states to deposit their charts and geographic coordinates? Because of course this is something that they do as states parties to the law of the sea, is when they establish their territorial sea, their exclusive economic zone, is they deposit their geographic charts. And this establishes the breadth from which these zones are established. So in the case of climate change and the receding sea lines, sea zones, maritime zones, there's a real question on what is the nature of the ongoing obligation on the part of states parties to deposit new charts, new geographic coordinates. And you can imagine that there is some reluctance to do so because we're talking about receding maritime zones. So that's one of the issues that the international community is struggling with, and exactly what is the ongoing obligation there. The other is in the case of the virtual and the disappearance of states. due to sea level rise, in that some island states might actually vanish and disappear. And what is the nature of any ongoing entitlement that they might have to the resources in that area? So it's a very unique and unfortunately fastly approaching legal question. Is there any ongoing entitlement of those states to the territorial sea or the economic resources surrounding those disappearing states? So these are very much new questions for us, and they haven't been resolved yet. They're very much questions of interpretation, and they bring to a head a number of different areas of the law. Climate change, of course, is dealt with in another completely different form, the UNFCCC, but they very much impact the way that the law of the sea operates and some of the obligations and rights of states parties in the UN Convention on the Law of the Sea. So thank you very much for the question. Yeah.
If I may, I have a last question for Marcus John on insurance. Do you think there is a difference between small ports and medium-sized, bigger ports, how they cope with their risk management and their insurance approach? Because the medium-sized and bigger ports are able to absorb risks, while smaller ports have to insure themselves. And what I see in my practice is that very often it is incident driven, and then they think, oh, I have to think about my insurance strategy. Is that also something you experience in your practice?
Yeah, I think that's, thanks Frans for that. I think with smaller ports, they have less insured assets, so less value to insure, but the principle remains the same, that they've got an exposure to their balance sheet if there's a catastrophic incident or a large claim that comes there. So just because they're small doesn't mean to say that the principle's not the same. And then in terms of smaller ports, for liability, sometimes they can generate quite large claims even though they've got few ship movements a year. So we had one claim in a small port in South Australia that was basically a grain port, not that one, a different one. And that had 50 ship movements a year, and they'd been taking larger and larger ships, and they were getting Panamax ships into there, and it was right at the edge of its, in terms of depths and tug capacity, it was right at the edge of its ability to handle a Panamax ship, and the pilot on board did his 50 ship movements a year and hadn't really been plugged into the central head office in terms of its training regime. And an incident happened and the ship struck the grain wharf there. And that was a situation of a small port that wasn't generating much income, that was sort of a sleepy hollow really, that the main port company hadn't really given much thought to. And that had quite a horrible risk profile, and that really did need its liability insurance. So even though it's small, it doesn't mean to say it's not going to generate a claim. And in fact, they can be worse risks from an insurance point of view than a large, well-found port. Yeah. And then in terms of dealing with claims, I mean, a port like Rotterdam has got an excellent legal department, I'm sure, Frans, and can deal with a lot of this stuff.
And the introduction to maritime law for port officials we use?
Correct. Yeah, absolutely. But then the small to medium-sized ports can really benefit from the expertise, I think, of specialist insurers that can help with that sort of thing, where they don't have that expertise in-house for themselves in terms of claims handling and contract advice, actually.
So your message is very clear. The smaller the port, the more reason for paying attention to your risk profile.
Look, I think that is right. That just because you're small doesn't mean to say you're below the radar.
Yeah.
Yep.
Thank you. Well, I think we come to an end of this session. And first I want to thank the speakers for their excellent and informative presentations. Thank you for that. And you as audience, thank you very much for participating in this session. And I think it is something for taking a hold on, that this legal session is maybe also something to take in a next program of a conference, for instance, in Bali in 2017. Thank you very much.